the quality of it and the quantity of it.
Okay, well, let's break that down. What do you mean by location?
By location, I mean where it is in relation to where the crime occurred. If there was a blood stain, for instance, 3 miles away, and then that would be a less significant stain if it could not be related back to the crime.
Okay, so you're trying to look for stains that would appear to be more relevant than other stains when you're talking about location?
Yes.
Okay, what about when you're talking about quantity? What are you referring to there?
By quantity, I would be looking for something that we would be able to analyze. A sufficient amount would be necessary to make some type of determination.
Okay, and what about quality?
By quality, I mean something that is not likely to be contaminated or degraded.
When you use the term contaminated, what does that term mean?
Contamination in the broadest sense can be bringing something into an environment that is unwanted or undesirable.
Well, if you were using the broader definition of contamination that you've just provided us with, could you look at the suspect's blood at a crime scene itself as being contamination in that sense?
In that sense, yes.
Is blood now classified as being a biohazard?
Yes, it is.
All right. Well, is there a more narrow or precise definition of contamination that is also used in the area of criminalistics?
Yes. As it relates to the evidence, contamination can also mean bringing a substance to a crime scene that would compromise the evidence and somehow affect the conclusions of an analysis.
Okay. So those are the various factors that you take into consideration that you just discussed with us in terms of deciding what biological evidence to collect and not to collect?
Yes.
If you have a trail of blood drops, do you necessarily collect every drop in the trail?
Not necessarily, no.
Okay, so then do you use the representative sample rule that you discussed earlier?
Yes.
All right. And what about debris at a crime scene? How do you go about deciding what types of debris to collect or not to collect?
With debris, I will try to collect things that are foreign or out of place to the location.
So you wouldn't pick up every single piece of trash that happened to exist at a crime scene?
No.
Or do you draw a certain diameter around the body and pick up every piece of trash within a certain diameter?
In certain instances I may, but not necessarily, no.
So if it's something that looks out of place, you might collect it?
Yes.
What about clothing? How do you go about deciding what clothing to collect or not to collect?
With clothing, I will try to identify items that seem out of place or in a strange location or may have some help in the investigation of a crime.
Okay, so again, it sounds like these kinds of decisions are common sense type decisions. Would that be correct?
Educated guesses, yes.
Okay. Directing your attention now back to June the 13th of 1994. At approximately 5:30 or so in the morning, did you receive a call?
Yes, I did.
Where were you when you received that call?
I was at home.
Okay. And what was the nature of the call?
It was a call from Criminalist Missoula informing me that there was a homicide we were requested to respond to in the West LA division.
Okay. And what did you have to do after receiving that call?
After receiving the call, I made arrangements with Criminalist Mazzola to meet me at the laboratory.
Okay, if you're the supervisor, why did Criminalist Mazzola call you?
Criminalist Mazzola was the primary criminalist on call that weekend.
Incidentally, is that her official designation, criminalist?
Yes.
Okay, and is she a trainee?
No, she's a criminalist.
Okay, so when you join the lab and become a criminalist, you're a full-fledged criminalist?
Yes.
All right. Now, where did you meet up with Criminalist Mazzola?
I met Criminalist Mazzola at the Piper Tech laboratory that morning.
Where is Piper Tech?
Piper Tech is at 555 Ramirez Street. It's about a mile away from Parker Center.
And why did you have to meet there as opposed to going directly to the crime scene, did you say?
I met her there so that we could meet and get the crime scene truck to respond to the location.
Okay. How many crime scene trucks does the Los Angeles Police Department have?
For the homicide criminalist, there was only one truck.
All right. Your Honor, at this time, I'd like to mark people's next in order.
160.
160, and it is a picture of the what would appear to be the Los Angeles Police Department criminalistics truck, which counsel has a copy of.
All right, proceed.
Your Honor, I'm going to place a 160 on the reverse side of this photograph. May I place this on the Elmo so that the
Yes.
witness and jury can see it? Court counsel, please. Name on it. Okay, sir, directing your attention to the picture that's above you. I guess you can see that from where you're sitting?
Yes.
Okay. What is that?
The truck to the left is the crime scene investigation truck.
Okay. What about the one that's over to the right that says hazardous chemicals? What's that?
That is another response team in the laboratory for hazardous chemical response.
Okay, so the truck that you were taking with Criminalist Mazzola was the one that's primarily featured on this photograph on the left?
Yes.
Okay. And where did you, that's fine, thank you. Where did you take that truck to?
We brought that truck to 360 North Rockingham.
Now, while you were in transit, was there any paperwork that you began filling out at in the truck?
Yes.
What was that?
That was the crime scene investigation checklist.
Okay. Your Honor, at this time I'd like to mark as People's 161 a document that's entitled Crime Scene Investigation Checklist.
All right, 161.
And for counsel's benefit, it's L10. Just one page. It's just the face page. Can we see that? Okay. Can we see that up here? Main monitor, please. Sir, directing your attention to the document that we've just marked as People's 161 for identification. Do you recognize that?
Yes, I do.
Okay, and on that document, there is a notation that says OIC name. It's about 6 lines down from the top.
Yes.
Who is filled in there?
That is A. Mazzola, or Criminalist Mazzola's name.
Okay, and what does OIC mean?
OIC is the acronym for officer in charge.
Okay. By the way, why do you call it OIC, or officer in charge?
That's just police vernacular for who's taking responsibility.
But technically, you're not sworn personnel, are you, criminalists?
That's correct.
All right. Now, why was Andrea Mazzola's name put in that location where it says OIC?
Ms. Mazzola was the primary criminalist on call that weekend, and it was going to be her responsibility to take care of the paperwork and direct some of the SID people to perform their functions.
Well, what other SID people would be at a crime scene that you would have responsibility for directing?
The photographer and the print specialists are under SID.
And did you anticipate while you were driving to the Rockingham location that Andrea Mazzola was in fact going to be the officer in charge in that sense?
Yes.
Okay, thank you. Now, at some point, Mr. Fung, did that anticipation change?
Yes, it did.
When was that?
After I had received the briefing by Detective Van Adder, it was determined that I would be the OIC at that crime scene,
Okay.
as far as the search team was concerned.
What time did you arrive at the Rockingham location?
I arrived there at 7:10 in the morning.
Okay, and why did you decide that you were going to become the person in charge of the investigation as opposed to Andrea Mazzola?
When I found out that it was a high-profile case and it was going to be a complicated scene, I decided that she should, in a sense, take the back seat.
Now, just so I can understand the relationship between a criminalist 1 and a criminalist 3, let's say that you had arrived at a crime scene with criminalist Mazzola that was fairly simple, routine, very little evidence to collect. What would the relationship between criminalist Mazzola and yourself have been at that kind of a scene?
Criminalist Mazzola would have determined the type of evidence that she would have collected and taken about the more procedural functions, such as directing the photographer as to what type of photographs he should take and directing the print examiners to the specific items to be printed at the scene.
Okay, so if it had been a simple scene, you would have allowed criminalist Mazzola to make these kinds of discretionary type decisions that you described earlier in your testimony regarding what to collect and what not to collect?
Under my supervision, yes.
Okay, well, what if you saw her making a mistake?
If I saw her making a mistake, I would tell her about it and correct her procedure.
Okay. Now, let's say that we were talking about a very simple scene where there wasn't a lot of evidence to collect, and you were working with Andrea Mazzola, and there was a dispute between the two of you. She says, why don't you collect that? You say, no, you collect that. No, you collect that. No, you collect. Or any other kind of a dispute. Who's going to win in that kind of a dispute?
Criminalist 3 takes precedent, and the criminalist 1 will have to do what the criminalist 1 will have to do what the criminalist 3 says.
So even at a simple crime scene, are you still designated then as being Andrea Mazzola's supervisor in that sense?
Yes.
Okay. Now, at this particular crime scene at Rockingham, was there ever a time where Andrea Mazzola did direct crime scene photographers
No.
or print people
No.
or anyone else that you saw?
No.
And what about at the location at Bundy?
No. She did not have any opportunity to direct anybody at that scene.
At both scenes, were you telling her what items to collect and what not to collect?
Yes.
Okay. Now, after you arrived at the location at Rockingham at approximately, you said 7:10 a.m., what was the very first thing that you did when you got there?
The first thing I did was I was met by Detective Van Adder, and he gave me a briefing as to what he had at the crime scene and what he wanted me to do.
Did he show you any evidence?
Yes, he did.
What did he show you?
He showed me a red stain on the driver door of the Bronco and a blood trail leading from the Bronco towards the front entrance of the residence.
Okay. Did you notice anything about the temperature at that time, or the weather?
It was fairly cool.
What about the lawns? Did you notice anything that looked like it could have been dew on the lawns?
I did notice that there was the grass was wet.
All right. And after the items of evidence were pointed out by Detective Van Adder, how did you go about collecting them? Did you do it alone, or did Ms. Mazzola help you? How did that work?
Ms. Mazzola and I worked as a team to document and collect the evidence.
Now, in terms of collecting biological evidence, particularly blood, have you been trained in how to do that in the standard technique that's used within the LAPD?
Yes.
Okay. And did you use that technique at the location of Rockingham for the purposes of collecting the evidence?
Yes, I did.
Your Honor, at this time I'd like to mark as Peoples 162 for identification a board that is entitled Collecting a Stain Demonstration.
All right, Peoples 162.
Yeah, which I'd like to put up. And I'd also like to mark as Peoples 163 for identification a brown paper bag and its contents. And I'd like there's a document in there that I'd like marked as Peoples 163A. This document is an inventory, Your Honor, that itemizes all of the contents of the bag as being A through L, Peoples 163A being the exhibit itself, the inventory.
Yes.
And I already pre-marked the items inside the bag. Mr. Fung, can you see this board from where you're standing?
I can't see. I'd have to get up.
Okay. With the court's permission, can the
Yes.
witness? Yeah. Okay, sir.
Can I stand over there? So, not blocking the Tweezers.
Perhaps we can pull up the photograph that's marked number 1 on Peoples 163.
Would you please?
Sir, does Peoples 163 demonstrate most of the major steps that are involved in collecting a stain?
Yes, it does.
And directing your attention to the photograph that's numbered 1 on this board that says number and measure stains, what does that photograph depict?
That depicts the documentation portion of the collection of a stain. We will number the stain with an identification number and then measure the stain as to its location and then have it photographed.
Okay, and this particular demonstration, who is portrayed in the photograph that's marked, that's labeled as 2, and the rest of the photographs?
That's Criminal Mazzola.
Okay, can we see number 2? Directing your attention to photograph number 2, what step does this involve?
This involves the collection of the control. In this photograph, she is selecting a cloth swatch and dampening it with distilled water.
Sir, I'd like to show you what we've marked as People's 163E for identification. It's a coin envelope containing a bindle. Can you open up that bindle and tell us what's inside of it?
I'm opening up the bindle, unfolding it, and within the bindle are 3 cloth swatches.
Your Honor, perhaps I can put this on the Elmo as well so that the jury can take a look at that.
All right, let's give it a try.
Yeah. Okay, you can kind of see them. Well, now I guess they look more like tablecloths than swatches. But Mr. Fung, what is represented here on the this exhibit?
You can see 3 cloth swatches in that. I guess it's a projection.
Okay, Your Honor, perhaps we could pass it around to the jury just so they could get a sense of how small the item is. Thank you. They should be warned, though, they have to be careful, otherwise they're going to
Not-
lose some
not
of our
to
swatches
sneeze.
here.
Yes. Start with your number 1, please. All right, the record should reflect that all the jurors have had the opportunity to observe the contents of 163E.
Maybe you can refold that for us, Mr. Fung, so we don't lose them. Okay, so in photograph number 2, maybe we can get that back up again. You are, that's showing her dampening these little tiny swatches that the jury has just seen.
Yes.
And how is she holding the swatches?
The swatches are held with a pair of tweezers.
Okay. And what does she dampen them with?
She's dampening them with distilled water.
All right. Now, directing your attention to the cell number 3 on our collecting the stain board, Peoples 162.
After she dampens the cloth swatch, she applies that swatch to an area very close to the stain.
Okay, so on this photograph, it actually looks like she's missing the stain number 5 by what could be about an inch or so.
Yes.
And why is she doing that?
She's doing that so that she will get a representative substrate control.
Okay, what does the term substrate refer to in this term that you've just used, substrate control?
The substrate is the object from which we are collecting a stain. In this case, it's a sidewalk. However, it could be a wall or a table. It's whatever we're collecting the stain from.
And what does the term control refer to?
Control refers to the process of looking for something that will somehow affect the conclusions of an analysis. So if there was some type of interfering substance on the sidewalk here, it should show up in the substrate control.
Does the substrate control serve any other purpose other than trying to tell you what might be on the substrate, if anything?
There are other side benefits in performing a substrate control. One of them is that our instruments and materials used to collect the samples are also checked during this process, and our technique to some degree is checked by the performance of collecting a substrate control.
Okay, so in other words, if the substrate control came up clean, that might provide some indication that your techniques in terms of collecting the stains were proper?
Yes.
Okay, but if it comes up dirty, does that necessarily mean, well, I'm not sure if dirty is the scientifically correct word, but if you test it and you find some biological evidence on there, what does that tell you, if anything?
That could indicate that there was also some type of biological substance on the substrate itself.
Meaning on the sidewalk in this particular demonstration.
Yes.
And that is the purpose of the substrate control, its
Yes.
intended purpose? All right, and why it's called substrate control?
Yes.
Okay. Now, after the substrate control is collected, what does she do with the substrate control?
The cloth swatch used to create the substrate control is put in a plastic baggie.
Okay. Sir, I'd like to show you a plastic baggie that I've just removed from People's 163E for identification. Do you recognize that particular type of material?
Yes, I do.
What's that?
This is the type of bag that we use to place the cloth swatch in once it has been applied to the sidewalk.
Okay, so after collecting this cloth swatch that may have nothing on it, she then puts it into the plastic baggie.
Yes.
And is that shown in photograph number 4, if we can have that up?
Yes, it is.
Okay, so she has the plastic baggie there in her right hand, it appears, and she's putting it in the coin envelope that's being held in her left.
Yes.
Now, how does she get the cloth swatch into the plastic baggie?
She puts them in with a pair of tweezers.
Okay. And then what does she do with it?
The plastic bag is placed in the labeled coin envelope, and she goes on to the next step.
Okay, maybe you can replace the plastic baggie in there now that we've seen what that looks like. Now, directing your attention to cell 5, labeled clean tweezers. Can we have that up there?
One, please. Name, model.
What is depicted in this cell?
That depicts criminal Smazzola cleaning her tweezers.
And how does she clean them?
She will wet a tissue with distilled water and wipe the tweezers on the moistened part of the tissue to wipe away any type of material that may be present on the tweezers.
So why do you have to clean the tweezers now if you've only collected the substrate control?
The tweezers are cleaned just as a matter of hygiene or lab practice, good lab practice.
Are you handling the substrate control then in exactly the same way you'd handle a stain, just as if it were a stain?
Yes.
All right. Now, directing your attention to the cell that's numbered 6 that says take new swatch, then dampen it. What does that show?
That depicts criminal Smazzola selecting a swatch which is approximately the correct size to transfer the stain onto it. She will select a swatch, dampen it, and with a pair of tweezers apply it to the stain and let the stain absorb onto the cloth swatch.
Okay, now, in number 6, she appears to have taken a swatch out of a little, what looks like a pill bottle. Is that right?
Yes.
And you say that she has to select one that's the right size. What do you mean by that?
When she's collecting, or when we collect blood stains, it's important not to collect a stain onto a swatch that's too large, otherwise the stain will be dilute and more difficult to analyze.
Is that why you're using these little tiny swatches that the jury has just seen?
Yes.
Because you want it to be as concentrated as it can be?
Yes.
All right. Now, directing your attention to the cell that's labeled number 6 that says collect stain, and in parentheses has number card removed, if we could have that. What is Ms. Mazzola doing here?
Ms. Mazzola is applying the cloth swatch to the stain itself.
So now she's actually collecting the stain.
Yes.
And in this case, it's the one that was numbered 5.
Yes.
All right. And she does that simply by applying the dampened cloth swatch to the stain itself.
Yes.
Now, directing your attention to the photograph that's in cell 8, what does that depict her doing?
That depicts her placing the cloth swatch in a plastic bag and then placing the plastic bag in the coin envelope.
And does that go in the very same coin envelope
Yes.
that you already put the substrate control in?
Yes.
And so you have a coin envelope that has a stain in one plastic bag and then a control in another plastic bag.
Yes.
And the coin envelope would be numbered to correspond with the number card?
Yes.
Okay. Thank you. You may resume your seat. Yeah. Sir, just following up then on the collection procedure, if you're collecting consecutive stains, let's say 5, and then you went on to collect stain 6, using the standard procedure that you've just described, how many times are you going to clean the tweezers between collecting stain number 5 and stain number 6?
All told,
Yes.
4 times.
No, between the two stains?
Oh, between the two
Yeah.
stains, once.
All right. Well, if you collect the, let's just see if we can get the sequence down, but between two stains. Let's say that you've collected the stain number 5.
Yes,
Okay. Then the next thing that you're going to do on number 6 is collect the substrate control.
yes,
Will you have cleaned your tweezers before doing that?
yes,
All right. And then you'd package up substrate control number 6,
yes,
and now you're going to collect stain number 6.
yes,
Okay, before collecting stain number 6, will you have cleaned your tweezers again?
yes,
Right. So it's twice under the standard practice that you clean the tweezers
yes,
between stains.
yes.
All right. If someone varies that practice by collecting the tweezers an extra time, I'm sorry, cleaning the tweezers an extra time, is that something that's over and above the standard practice that you're using in LAPD?
Yes.
All right. Okay, so is the procedure that you just described the same general procedure that was used to collect the stains at Rockingham?
Yes, it is.
All right. Your Honor, I'd like to mark as my next exhibit People's 164 for identification. A diagram I'm sorry, it's already been marked. I'd like to use what's already been marked as People's 120, which is a diagram of Rockingham.
All right, People's 120.
Mr. Fung, perhaps you can step down if you need to take a closer look. Have you had an opportunity to look at this board before today?
Yes, I have.
And the photographs in it as well?
Yes.
Okay. Now, directing your attention to photograph A on this board, there are in that photograph what appear to be little tiny cards in the street and on the driveway. What do those cards represent?
Those represent items of evidence or tags for items of evidence that we were going to document.
Okay, so these are the cards that you used when you were previously describing, I think, what was step number 1 on the demonstration, numbering and measuring the stains.
Yes.
I would check that testimony is being illustrated here, as opposed to simply to what you said.
Sustain, rephrase the question.
Okay, these are the cards that you used.
Yes.
Yeah, and are these cards that you put out or that Andrea Mazzola put out in your presence?
Yes.
Right. And for what?
Check to that is being vague.
Overruled.
You should say particular.
Overruled.
And
That's
for what
not-
purpose?
Wait, it's not an appropriate objection. Proceed.
Thank you. Sir, and for what purpose were these cards put out?
The cards were put out to mark items of evidence or locations that we wanted documented.
Okay, now, there's also a call-out line that goes from the photographs that are labeled A and B on this diagram. What does that call-out line portray the general area that you saw these two stains? The stains in A and B?
Yes.
Okay, one's in the street, the other one is in the driveway.
Yes.
All right. Now, if you look closely now at the photograph that's marked C on this diagram, here we can have that one. I don't know if the resolution on the large one is good enough, but Mr. Fung, maybe you can take another look at the smaller photograph over here that's C. Can you actually see the numbers on the cards?
Yes, I can.
And do those cards represent stain number 5 and 6? Well, there's 5, 6, and then there's a letter.
Yes.
Okay. And directing your attention to the call-out line from that photograph, does that demonstrate the general area where these 3 stains were located?
Yes, it does.
And with respect to the photograph that's marked D on this diagram, does that represent stain number 8 as portrayed in the, is that an 8?
That's a B.
Oh, I'm sorry, a B. Okay. And does the call-out line show where B was?
Yes. Approximately, yes.
Okay. And now, looking at the photograph that's marked F on this diagram,
Yes.
what does that show?
That shows the stain that we labeled C.
Okay. And now, looking at photograph I. Maybe we can have I. Which stain is depicted in I?
That is number 7.
Okay. And does the call-out line represent the general area where 7 was collected from?
Yes, it does.
And now directing your attention to photograph K. What does that depict?
That depicts the location where number 8 was collected.
Okay. And the call-out line on that?
Yes.
Okay. You can resume your seat. Now, did you collect a stain on the car door of a Bronco that was located at the Rockingham location?
Yes.
Do you have to, in order to tell us times that various stains were collected, refer to something, or did you memorize that?
I would have to refer to notes.
What type of document would you have to refer to?
There's an evidence collection sheet that we fill out.
Is that the crime scene identification check, part of the crime scene identification checklist?
Yes.
Okay, that was the document that we put up earlier that had, that we were talking about in terms of who was in the box or the line locate across from where it says OIC, officer in charge.
Yes.
And when is that particular document filled out? Is it at the crime scene or after?
The certain portion, well, most every portion is filled out at the crime scene.
Okay. So the portions documenting the numbers that you collected and their locations, when are they filled out?
Those are filled out at the crime scene.
Do you know who took the measurements of the various items here that are listed in the crime scene identification checklist?
Both Criminalist Mazzola and myself were working as a team to measure these items of evidence.
So you work together in that.
Yes.
And with respect to the times that are written down there, as to the evidence collection that occurred at Rockingham the morning of the 13th, when were those filled out?
Those were filled out at approximately the same time that they were collected.
So they are not exact.
No, they're not.
All right. Approximately how many pages of documentation, including the crime scene identification checklist, did you generate in this case in connection with the evidence that you collected, would you say?
There were approximately 80 sheets of notes and reports generated.
Have you had an opportunity to look those over prior to your testimony?
Yes, I have.
And are there some clerical errors in some of those reports and notes?
Yes, there are.
Okay. When you're at the crime scene, do you fill these particular documents out? Well, did you fill this particular document out? I'm referring to the Rockingham crime scene identification checklist in pen or in pencil.
This, I believe, was done in pencil.
And why would you use a pencil as opposed to a pen?
If a mistake was made, then you could easily erase it and put in the correct information.
So it's a document that you are filling out in the field,
Yes.
and if there's a mistake, you simply erase and then write over it.
Yes.
Okay. Now, can you tell us at approximately what time the item on the Bronco door was recovered?
That was recovered at approximately 8:15 in the morning.
Now, perhaps I can put that exhibit up. It's People 62B, I believe. What does People 62B for identification depict?
That depicts me pointing at the stain
Okay,
that was on the door handle, or near the door handle.
and that's what was collected at approximately 8:15 or so in the morning?
Yes.
Now, when you were at the Bronco that morning, could you see any other blood inside of the Bronco?
I did see what appeared to be stains in the interior portion of the vehicle.
Where were you standing when you saw those?
I was standing at the front passenger window.
So on the other side of the vehicle, as depicted in this photograph, People 62B.
Yes.
Right. And what did you see when you were looking in?
I saw some reddish stains on the console and near the window ledge of the driver door.
Was there enough light for you to be able to see the floorboard on the driver's side?
I could see the driver's floorboard, but I couldn't make anything out.
On it.
That's correct.
Okay. Now, with respect to stains 4 through 6, what time were those collected approximately?
Stains 4 through 6 were collected approximately 9 o'clock.
And 7 through 8, approximately when were those collected?
7 and 8 were collected approximately 9:15.
Now, when you were looking at the various blood dots that you previously described that are depicted on the diagram here that's been previously marked as People's 120 for identification, did any of those blood dots appear to be stepped in?
No,
What condition did they appear to be in?
they appeared to be dry. and they had a reddish tinge to them. They appeared fresh.
Okay.
All right, Mr. Goldberg, would this be an appropriate point?
It would, Your Honor.
All right. How about if you take that exhibit down for me real quick? All right, ladies and gentlemen, we're going to take our recess for the morning session. Please remember all of my admonitions to you. Do not discuss the case amongst yourselves. Do not form any opinions about the case. Do not conduct any deliberations till the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case. Council, we will stand in recess until 1:30, and let me see council without the reporter at the sidebar. All right, Mr. Fung, you're to return 1:30. Defendants again present before the court with his counsel. People are represented. See, we have a new addition, Brian Kelberg. On behalf of the people, good afternoon, sir. All right, we have two motions on for this afternoon. One has to do with the cross-examination of Dr. Golden. The other has to do with admissibility of autopsy photographs. Mr. Kelberg.
Your Honor, if it would please the court and counsel, I prefer to address the Dr. Golden motion first.
All right. Two issues as to Dr. Golden.
Correct. And I did receive counsel's response filed, I believe, on Friday. As I understand it, defense's response was not filed under seal. I've heard some public commentary regarding it. Ours was filed under seal, and of course I assume the court has had an opportunity to review what we say in our brief. Let me begin by acknowledging what is a somewhat difficult position for me, and especially somewhat difficult because my colleague, Mr. Harmon, is sitting right behind me. I think the court probably recognized, if it reviewed Mr. Harmon's motion regarding the scope of cross-examination of experts, and review my motion concerning the scope of cross-examination of experts, that we seem to be talking about the same topic, but seem to reach very different views of what the law is in this area. And I think it's clear to say that Mr. Harmon didn't consult me when he filed his motion, and I think it's clear that I did not consult him when Mr. Lynch, who is sitting, I don't know if the court has met Mr. Lynch, but Mr. Lynch is my colleague who has assisted me ably on these motions, along with Ms. Lewis on the photographic motion, that we did not consult Mr. Harmon. I say this because I believe that in testing expert testimony, one should test it on the merits of the science or the medicine. And I believe the law supports that position. And as a result of my perspective, I do not believe that one's personal use of drugs when the person is not a percipient witness, and the question may be whether the person's perceptions or ability to perceive or recollect were affected by drugs, that becomes an issue. And I carry that over, and I realize that there is this dichotomy, and probably I won't ride in the same elevator back with Mr. Harmon after court this afternoon. He's given valued assistance to our office from Alameda. But the law is the law, at least as I see it, and it applies whether it's my motion, Mr. Harmon's motion, or a defense motion. So I have to begin with that caveat. It's a somewhat difficult position. I believe our position on the law is the state of the law on scope of cross-examination of an expert. Let me begin then with the alleged gun incident of Dr. Golden. The fact that just a week ago the Academy Awards were given out and Tom Hanks won for the second year in a row caused me to review the movie for which he won the Oscar the year before, Philadelphia. And I think the court may have seen the movie and may recall a scene near the end when Tom Hanks is dying of AIDS. He's at his hospital bed dying when his lawyer Denzel Washington comes to report the success from a big verdict that the jury has rendered in his wrongful discharge suit. And at that time, Tom Hanks whispers a joke to Denzel Washington, which as Denzel Washington is leaving the hospital, he enters an elevator where there's a patient in a wheelchair and a cervical collar, and he repeats the joke to that patient. What do you call 1,000 lawyers chained together at the bottom of the ocean. And before Denzel Washington can even give the patient the punchline, the patient, with a bit of a sardonic smile, provides it a good start. It is unfortunate, Your Honor, that the legal profession has a perception in the population at large that is something less than favorable. It is clear that we have perhaps only ourselves to blame, that we sometimes use trick and artifice, it seems, in cross-examination or direct examination, and cause witnesses to be made to look foolish when in fact it's a very credible and truthful witness. So we do have only ourselves to blame for this perception. And the incident involving Dr. Golden, even if the incident occurred in a way which is the most favorable to the defense, that is a real weapon and the threat being made regarding taking out lawyers, that does not show bias against these lawyers. After all, Mr. Hodgman, the prosecutor at the preliminary hearing, is a lawyer. We are lawyers. If anything, at its best, such evidence merely suggests what is a nationally held view, that you could take 1,000 and a whole lot more lawyers, chain them to the bottom of the ocean, and society might be the better for it. I have a different view. This court was a lawyer for many years. I've been a lawyer for many years. Defense counsel have been lawyers for far many years more than I have. And I don't think any of us would be in this if it were not an honorable profession. And I speak of that both from this side of the table and from that side of the table, because someone who is very near and dear to me practices law from that side of the table, not this side of the table. And so when the public has this concern about lawyers, it bothers me. But if the issue is, did Dr. Golden make mistakes in the way he performed the autopsy, how is this view of lawyering going to assist a jury in deciding whether mistakes were made or not? Let me tell this court, there is no question mistakes were made, and we're going to bring out those mistakes. There is nothing to hide when one looks at the evidence. And we have no fear that when all of the evidence is out and all of the evidence is presented to this jury, that they will make a fair and rational decision. Because although in Dean Uelmen's response, I think to the photographic motion, he used the pejorative term incompetency, number one, that's not a term we used, and that is not a term which is going to apply to what Dr. Golden did. But when you use a term like incompetency as a pejorative, it conveys an image that not only were mistakes made, but they really matter. They go to the heart of cause of death, manner of death. Was there one killer, multiple killers? How did these people bleed? Should blood be on the perpetrator, and so forth? Well, what the evidence is going to show, and I have the utmost confidence my colleagues will be able to argue successfully to this jury, is that whatever mistakes Dr. Golden made, they do not impact on any issue in this case. Let me use the most well-known example. Everybody talks about, my God, he threw away the stomach contents of Nicole Brown Simpson. What an idiotic thing to do. Well, I think it's fair to say the evidence will show she did not die of food poisoning from Mezzaluna Restaurant. And she did not die from drug intoxication from taking too many barbiturates that are still in her stomach. If one wants to look at the medical reasons why one would save the stomach contents, then that is a perfectly fair issue to present to this jury. And I submit when the evidence is out, there is no medical issue that warranted saving that contents. Because the evidence will show that Dr. Golden did what any sound forensic pathologist examining a body in this situation would do. He opened the stomach, he examined its contents, he wrote it down contemporaneously to his examination. And the form will be in evidence for all the world to see that he, not by just luck, but by competency, examined and found rigatoni in Nicole Brown Simpson's stomach, and found the volume to be 500 cc's. And this court may remember when Ms. Clark was examining, I believe Tia Gavin is the server's name, somebody came in, I guess at the lunch hour, with some document in response to an SDT, which Ms. Clark didn't have the foggiest idea about. And that's my responsibility, because I thought, getting into the case somewhat belatedly, that, gee, it might be interesting to see. Was it a lucky guess by Dr. Golden that she had rigatoni in her stomach? Or did he, in fact, make an accurate observation? And lo and behold, as the evidence has already shown, he made an accurate observation. And that the evidence will further show, Your Honor, that when someone is able to identify intact food in the stomach, not what I say, not what Dr. Golden says, but, for example, one of the most recognized forensic pathology texts in use in this country, Spitz and Fisher, I'll give them a plug, Spitz and Fisher, Medical Legal Investigation of Death, 3rd edition. What do they say? And what's the evidence going to show? It's going to show it has been found that stomach contents which are readily identifiable by naked eye inspection were usually ingested within a 2-hour period. And of course, the court will recall the testimony is that Ms. Brown left the restaurant between 8:30 and 9. One witness said 8:45-ish. And I assume that my colleagues will argue to the jury that it is reasonable to assume that one doesn't put in the last bite of food and in the next breath take the first step out of the restaurant. If one is talking about 10:15 versus 11 o'clock, we don't need Dr. Golden's incident with the gun to test the stomach contents and to test the significance of that stomach contents. And in fact, what is some of the strongest evidence on stomach contents comes from the words under oath of the defense expert that Mr. Cochran has indicated to this jury they will hear from, Dr. Baden, who in a 1988 case for the prosecution said that the time of death where he was able to identify intact pieces of potato and meat with clear margins around the food, indicating lack of digestive process, that indicated death less than 1 hour from the time of eating. And Dr. Baden's view is that the stomach empties in something like or less than 2 hours, which may or may not be medically correct, but nevertheless, from the words of their own expert, the evidence of the stomach contents will show that the time of death is in fact consistent with 10:15 and not consistent with 11 o'clock. So in spite of everybody talking about stomach contents and throwing them away, there's only one reason the stomach contents should have been saved in this case, as the evidence will show. To cover the backside of Dr. Golden so that Dr. Baden could have examined it. It's defensive medicine. In the practice of clinical medicine, it's doing unnecessary tests to protect the doctor from being sued when there's an adverse outcome. But if the issue is going to be the medical judgment and the medical findings that that evidence can support, there is no question that we are confident that the evidence will support the view that the stomach contents, if to be used at all for estimating time of death, supports 10:15 and refutes 11 o'clock. We don't need this alleged animosity towards lawyers to test that. Now, this is assuming that the incident occurred the way it did. The evidence is anything but clear that the incident occurred that way. In fact, there's an issue. Is it a real gun or a toy gun? Is it said in jest? And most importantly, who's it in reference to? The lawyers in the Simpson case? This is a comment allegedly made 13 days after Dr. Golden testified at the preliminary hearing. 13 days. Now, if Dr. Golden felt that he was subjected to what Dean Uelmen calls a blistering cross-examination by Mr. Shapiro, I have to say, I've read it, I've watched it, and if that's blistering, I can only imagine how Dean Uelmen would characterize Mr. Douglas's cross-examination of Mr. Shipp or Mr. Bailey's cross-examination of the two police officers. I would assume he'd use a term like thermonuclear. The point is that if Dr. Golden were so upset, you would have had an incident that day, that night, the next day. We know, I think the court could almost take judicial notice that coroners perform autopsies, one, perhaps two autopsies, every working day they're there when they're not testifying in court. And so when they're testifying in court, they're being hassled by a lot of lawyers. DAs, defense attorneys, they want them there at a particular time, the doctor can't be there. They want to talk to them in advance to see what they're going to say, the doctor doesn't have the time. there is this inherent tension between their responsibilities and our responsibilities. And I say our, I mean the legal profession, not just prosecutors. And so any animosity he might have, if it in fact exists, is against the process in general, is not shown to be against these lawyers. And in fact, is a classic 352 circumstance for which cross-examination should be precluded. We are going to have to litigate what happened. Dr. Golden does in fact have a Fifth Amendment privilege, and in fact one of the cases that I pulled up this morning, the Jennings case, I think is particularly important, 53 Cal 3rd 334, page 371, where the court noted that the fact that evidence would consume a considerable period of time, especially because the witnesses would probably invoke the Fifth Amendment, necessitating appointment of independent counsel for them, was a valid basis for the court to say, forget it. 352, let's keep it out. And incidentally, Dean Uelmen in his response does not point out the United States Supreme Court decisions such as Delaware versus Van Arsdale, which I can give the court a citation to. I'm sorry. And the California Supreme Court cases which follow it, which say that there's nothing inherently inconsistent between a court exercising its discretion under 352 to exclude basically irrelevant, prejudicial in the wrong sense of the term prejudicial evidence, and having the defendant an opportunity for his cross-examination under the Sixth. There is no inconsistency whatsoever. If we're going to spend the time litigating the facts that surround the incident with Dr. Golden, then I suggest to the court we divert the attention away from the jury's understanding of the medical issues involved. Now, perhaps the defense prefers that, but it seems to me where on direct examination many mistakes will be brought out from Dr. Golden, and we will assess the medical and scientific impact of those mistakes, that this incident involving animosity is simply the kind of thing that should be excluded. And if it's not excluded, think what the court buys itself into. Prior consistent statements, 791-1236, because the contention is that the bias arose as a result of the blistering cross-examination of Mr. Shapiro. Therefore, his preliminary hearing testimony, his grand jury testimony, where they are consistent with his testimony at trial, and prior to the formation of the alleged bias that is the subject of this collateral matter, become admissible under 791 and 1236. I don't think it helps anyone to spend the time going over that. We should be talking about science and medicine, not talking about prior consistent statements about matters that really have nothing to do with the bottom line issues of the reliability and validity of the findings. That is my view on the incident involving the gun. Does the court want me to go on then to the other two?
Yes, please go on to the other incidents.
Okay. The other incidents, again, 1990 incidents, where Dr. Golden made certain mistakes. He misdiagnosed, I'm not sure is the correct word, he opined regarding entry and exit wounds in an incorrect fashion, and he was involved in a determination of distance regarding where a gun was at the time the shot was fired, which turned out to be erroneous. Our position on the law is very clear, Your Honor. These are specific acts of alleged conduct which do not reflect a course on credibility, moral turpitude. They are not prior felony convictions, etc. So they are not admissible because they only serve to create the impression that he has a character trait for being an incompetent physician, a negligent physician, and that he acted in conformity with that, the classic 1104 of the Evidence Code prohibition. Now, I thought it was interesting that Dean Uelmen cites a federal case, and by the way, there's a subsequent Colorado case, I can give the court the citation, which refuses to follow it. But the interesting thing about the federal case is you've got an expert testifying for the plaintiff in a malpractice action, and the expert is going to be asked, and is asked, number one, if he had inflated his invoices when being an expert witness, and he testified he had. Now that I have no disagreement with. If somebody does that, that's an act that reflects on truth and veracity under Wheeler. Specific act, not barred because of Prop 8, and it bears on truth and veracity. That's fraud. I mean, plain and simple. The other thing was he'd been sued 3 times in medical malpractice actions, and the court said that was fair game on credibility. But the rule that was cited by the court is 608B of the Federal Rules of Evidence. 608B is a rule analogous to the Wheeler decision. It deals with specific acts of misconduct offered on the issue of truth and veracity. And what's interesting is this decision is, I think, 91. In 1986, the United States Supreme Court, in a case called U.S. versus Abel, which I can give the court the citation if it wishes, had to decide whether 608B and the limits on cross-examination with specific acts of misconduct on truth and veracity also barred cross-examination on specific acts that reflected not on truth and veracity, but on bias, which is the argument that Dean Uelmen makes in his response papers, that in response to the first incident of the gun, that it reflects his bias. The decision in the federal case is dealing with the malpractice actions, and yet the court cites 608B. And I don't think anybody suggests that being sued in a malpractice action reflects a lack of truth and veracity on the part of the doctor. But by relying on that section, the court has, I believe, mischaracterized what the legitimate purpose would be if there were a legitimate purpose. Our position is that the case we cite, Hinson, addresses this clearly for what it is. It is mistakes that are made in the past create an impression that you have a character trait to act in a sloppy fashion. You acted in conformity with that character trait. Ipso facto, you must have been negligent in this case. Well, this stuff is so excludable under 352 for the very reason that Dr. Golden is going to admit to his mistakes, or that his mistakes are going to be shown. There's not going to be a question as to whether or not he made mistakes. You don't need this evidence. It's the very kind of evidence 352 is intended to exclude. It's not the issue for this jury. This jury is going to have to decide not whether mistakes were made, but the significance of any mistakes, if there is any significance. And on that, his prior mistakes will shed no light whatsoever. Now, of course, you've got classic 352 problems, and these are old, 4.5, 5 years ago. They deal with 2 cases out of 6,500 that he's done. They deal with gunshot wounds, not stab wounds. What do? Do we litigate the merits of those 2 cases, litigate the merits of the 6,498 that the defense doesn't have any evidence to suggest he did improperly? Or do we litigate the merits of what he did in this case and focus, as I believe we can, on what the literature shows, what the research material shows, and what other people who practice in the area believe with respect to these issues, as well as Dr. Golden's view. So bottom line, Your Honor, is Hinson is apposite, not inapposite. The federal case is obviously not a ruling that really reflects what the true state of the law is that they cite for their proposition that this evidence is admissible past medical malpractice complaints. And the evidence should be excluded so that we can focus on what is important and let the jury make an honest call, whatever way it is. Because I won't be here at the end of the case when it's argued, and there are other people in this office that have a lot of interest in how it comes out, but I'm going to be perfectly candid with this court. Since I'm not arguing the case, once I'm done, I'm out of here, and it's not soon enough for me. I would have preferred Mr. Hodgman's health have permitted him to be down here. So I don't care whichever way the jury goes, as long as they make an honest decision on the evidence and not be misled. The last thing I leave you with is just, I have considered how some of these witnesses must have felt after they left their experience as witnesses in this case. And I got to feel that Mr. Kalin is not going to send Ms. Clark a Christmas card unless he does so because he hears some DA making a comment that he wouldn't do so, and he'll show otherwise. And there are other witnesses who I sure feel that they were excoriated by the defense in cross-examination in an unfair way. Do we honor the profession? Do we honor the practice of law and what law is supposed to stand for? If we deviate into these little tributaries of irrelevant baloney, I suggest that if the defense can prove that Dr. Golden made mistakes that significantly impacted on any issue in this case, they've got the resources to bring in some top guns to try and show that. And we'll cross-examine them and test their ability. One last thing, I'm sorry that I forgot, because I think it's the Bible. I do not hold myself out as an expert on the Bible, but I believe there's a phrase that says something to the effect, "Let he who has not sinned cast the first stone." Dr. Baden, our foremost pathologist, according to Mr. Cochran, has made a few mistakes of his own, as the evidence would show. Let me focus on one that I think may be relevant if the court believes Dr. Golden's mistakes are relevant. Dr. Baden, when he was in New York as a medical examiner, signed off on a death of an alcoholic.
Let me just interrupt you. I don't really want to go down that road at this
Okay,
point.
that's fine, Your Honor. I think the court clearly understands what we submit should be the real issues and why we believe these extraneous matters do not serve a search for the truth, which I've always understood, at least in our Izizaga prosecutorial discovery days, is what a trial is intended to be, a search for the truth. So on that basis, we believe that our motion is well taken and it should be granted as it is spelled out. Thank you, Your Honor.
Mr. Uelmen.
We, of course, are interested in a search for the truth as well, and we subscribe to the aphorism that the best engine in the search for the truth is cross-examination. And what this motion really addresses is what opportunity the defense will be given to cross-examine an expert witness as to areas with respect to his qualifications, his bias, the credibility, and the weight that the jury should give to his testimony. There are essentially two items of evidence in question here. First, on July 21st, 1994, 13 days after he got off of the witness stand in the preliminary hearing of this matter, Dr. Golden was seen displaying a firearm on the premises of the Los Angeles County Coroner's Office and was heard to remark, "You know, we ought to go out and kill 9 or 10 of those attorneys." The other item relates to the fact that, and it's conceded, on 2 prior autopsies, Dr. Golden made serious errors in examining the character of wounds. In one case, mischaracterizing entry wounds and exit wounds completely backwards, and in the other case, indicating that a shot was fired from several feet away when in fact it was a contact wound. Now, with respect to all of this evidence, what we're talking about is the weight and the credibility that the jury is going to give to the testimony of Dr. Golden with respect to some very key issues in this case, including the time of death, including the nature of the wounds, whether the wounds indicate that they were made by 2 different weapons, as Dr. Golden indicated in his preliminary testimony. And when ultimately, what we were just treated to really was akin to what we're going to hear in closing arguments. I know Mr. Kelberg indicates he won't be here for the closing argument, but I think we got a pretty good preview of what we can expect when the jury is asked to weigh the credibility of opposing expert witnesses. And I assume that Your Honor will instruct the jury in conformity with Section 2.80 of the Calgic instructions that you may consider the opinion with the reasons given for it, if any, by the expert who gives the opinion. You may also consider the qualifications and credibility of the expert. You are not bound to accept an expert opinion as conclusive, but should give to it the weight to which you find it to be entitled. Now, the only guide that the jury is going to have to approach that function of determining what weight they should give to the opinions of the experts is what they heard in cross-examination of those experts with respect to their qualifications and with respect to their credibility. And the evidence code clearly recognizes that when we're dealing with expert witnesses, we have to test their credibility in ways that we don't test the credibility of normal witnesses. Section 721 of the evidence code provides that a witness testifying as an expert may be cross-examined to the same extent as other witnesses, and, in addition, may be fully cross-examined as to his qualifications, the subject to which his expert testimony relates, and the matter upon which his opinion is based, and the reasons for his opinion. And the California cases make it quite clear in applying that rule that we give the greatest and widest latitude to the cross-examination of expert witnesses, more than we do in the case of any other witness. Now, Mr. Kelberg repeatedly mischaracterizes the nature of this evidence as bad character evidence. And that simply is not the principal grounds of relevance, although even on that issue, his argument is simply incorrect. He is arguing that the only bad character that can be used to attack a witness is a felony conviction. And that is simply not true anymore in the wake of Proposition 8, which provides that all relevant evidence is admissible.
I think that's what I heard.
I can assure the court that's not what I said. Wheeler
No,
clearly
now,
stands.
counsel, I'm not addressing you, Mr. Kelberg.
Sorry, Your Honor.
I'm
All
just
right.
indicating that's not what I heard.
Well, the theory on which this evidence is going to be offered is not that it is evidence of Dr. Golden's bad character and that the jury should disbelieve him because he is a bad man who doesn't conform to the regulations about bringing firearms to his place of
Dean
employment.
Uelmen, let's cut to the chase. What it's interesting about is an expression of bias against perhaps these attorneys and a demonstration of professional incompetence.
Well, let me address those separately. First of all, the expression of bias. It is more than just an expression of bias. I think it's relevant to both 780F, which relates to bias and hostility, and 780J, which relates to an attitude toward the giving of testimony, which doesn't necessarily have to relate to a specific feeling of hostility or favor to one side or the other. 780J addresses a more general attitude about the giving of testimony. Now, what Mr. Kelberg is saying essentially is we have an explanation for what Dr. Golden did. Our explanation is that all he was expressing is general animosity toward the legal profession in general, or perhaps he was making a joke. Well, that's an explanation that should come from Dr. Golden. We certainly have a good faith basis to ask him what he meant by a statement about we ought to go out and kill 9 or 10 of those attorneys. We think there is ample indication in the record that at the time that statement was made, it was shortly after Dr. Golden had been subjected to cross-examination. We have information not reflected in these statements that at the time this incident occurred, Dr. Golden mentioned Mr. Shapiro by name. We know that at the very moment this statement was made, Dr. Golden was being subjected to intense media scrutiny, that a television special was being prepared about Dr. Golden and his competence in a long series of cases. So there's ample reason for us, it's not paranoia, Your Honor, for us to believe that Dr. Golden was talking about us when he said, I ought to go out and shoot 9 or 10 of those attorneys, that those attorneys are the 9 or 10 attorneys who are engaged in representing Mr. Simpson in the defense of this case. But even if we can characterize this as some broader hostility about attorneys in general, we believe there is ample basis to conclude that that hostility arises from the role that Dr. Golden plays as an expert witness and his cross-examination in the course of presenting his opinions.
What is your response to Mr. Kelberg's argument regarding 352 and Fifth Amendment problems?
Well, first of all, we don't believe the Fifth Amendment is a serious problem for the prosecution. They have available to them immunity if Dr. Golden insists that he's not going to testify in this case because his testimony may incriminate him of a criminal offense. There are numerous ways that the people can deal with that, including a statutory grant of immunity.
But that's completely within their discretion, and tactically I'd be astonished if they did that. So that doesn't help us much.
Well, Your Honor, whether there's any realistic interest in the prosecution of Dr. Golden, I think can be gleaned from the records that have already been submitted to you. You have an opinion already rendered by the city attorney's office, incidentally, without even talking to Dr. Golden, indicating that they were not going to pursue prosecution of this case. So whether there is any realistic fear of self-incrimination, or whether that would be simply be used as some sort of tactical tool to avoid cross-examination of this witness, it can be dealt with through the device of immunity. But I don't think we even have to deal with it until there has been an invocation of the privilege, and there's no indication in anything that has been presented to the court that there is any risk of self-incrimination, much less any risk that the witness will refuse to testify on that ground.
But don't we have an ethical issue to broach before we get to that? Then if we have the suspicion that a witness may claim the Fifth, don't we have a problem?
Well, we can call him out of the presence of the jury and ascertain whether he's going to invoke the privilege so it isn't done in the presence of the jury, but I believe that's the only ethical problem we would
All right.
have. Your Honor also asked, with respect to another aspect of
352 argument.
the
Mr. Kelberg.
352 argument. 352, of course, has to be approached from the perspective of the relevance of this evidence to show bias. And Your Honor has already addressed that question in the context of Detective Furman's testimony. The extent to which 352 is appropriate where the relevance of the cross-examination goes directly to the bias of the witness. And we believe that whether the bias arises from racial animosity or whether it arises from animosity to any sort of professional group, it doesn't make any difference.
So we want to put lawyers in a protected class like we do race?
Well, in terms of the credibility of the witness, well, yeah, we seem to be plagued with jokes in this case. Frankly, even if this was intended as a joke, a coroner who would make a joke about killing 9 or 10 lawyers 1 year after the tragedy of what happened in San Francisco when a gunman went into the offices of a law firm and shot 8 or 9 people, it's just not a funny joke. And if it's a joke, let the jury hear it and let them decide what bearing that has on whether they should give weight and credibility to the opinions of this expert witness. Now, with respect to the prior mistakes, which are conceded, they, of course, go directly to the question of the qualifications of this witness to give an expert opinion. We have to note that one of the key areas in which Dr. Golden is going to be testifying is his examination of the wounds of the victims and rendering opinions about whether those wounds are consistent with a particular knife, which he was given by Detective Van Adder, whether they are consistent with more than one knife, and whether they are different morphological wounds.
But aren't we talking apples and oranges here, gunshot wounds?
No, I don't believe we
Let me
are.
tell you my two concerns. My two concerns here are apples and oranges, gunshot wounds versus cutting wounds. And my second concern is the argument brought up by Mr. Kelberg. Let's assume that Dr. Golden in his career has performed approximately 6,000 or 7,000 autopsies. And the prior consistent statements that he raises. Do I then have to, if I allow you to go into that, then do I have to allow the prosecution to then bring in evidence of 6,000 other autopsies that he's done where nothing's been wrong?
Your Honor, you know, very frequently, an expert who is on a witness stand testifying as to an expert opinion is asked, Mr. Expert, have you ever made a mistake? I'm sure you've heard that question posed 100 times. And I'm sure you've heard the same answer all 100 times. The expert says, well, not that I'm aware of. Here we have two conceded mistakes. We have an expert who has admitted that on 2 prior occasions he rendered an opinion and that opinion was wrong. And how was the opinion, the wrong opinion, corrected? By an addendum to the autopsy report. How many of the 6,500 autopsies performed by Dr. Golden have addendums attached to his report in which he makes corrections in his conclusions? We know one of them does, and that's the autopsy report in this very case, in which numerous addendums have been attached, and we're going to hear, I'm confident, Dr. Golden suggesting that on reconsideration, some of the opinions he previously rendered may not have been correct, that he now has changed his opinion. When the jury weighs what credibility they should give to this doctor's opinions, they are entitled to know that on 2 prior occasions he was wrong and it was conceded that he was wrong. So we're not fishing around through lots of prior autopsies looking for mistakes. We know going in that there are 2 conceded mistakes that the jury should know about. And those mistakes are relevant mistakes. They are mistakes that relate directly to the examination of wounds and the nature of wounds. Now, Dr. Golden may have an explanation. He may say, well, I may be incompetent in examining firearm wounds, but I'm not incompetent in examining knife wounds. That's fine. The jury should hear that explanation, and they should weigh it in terms of deciding what credibility and weight they want to give to Dr. Golden's opinion. Our experts will suggest that the same kinds of skills are being employed in the examination of wounds, that people ordinarily aren't experts just in gunshot wounds or knife wounds, that a pathologist should be an expert in the examination of any wound, and his inability to distinguish an exit wound from an entry wound or to identify a contact wound goes directly to the credibility and weight we should give to his opinions about what kind of knife slashing produced a particular wound, what kind of weapon produced it, or whether more than one weapon may have produced the wounds in this particular case. These are areas that we should explore on cross-examination. What we're talking about here is the right to cross-examine. And then we'll get to the question of arguing to the jury, as Mr. Kelberg was doing, about whether they should give greater weight to Dr. Golden or to Dr. Baden or to other experts who may testify in this case. But that function is a function reserved to the jury, and if Your Honor is going to tell that jury in your instructions, give to the expert's opinion whatever weight you think they deserve, then the jury is entitled to hear cross-examination about these highly relevant issues.
Thank you, counsel.
This court would hear a brief response, or is the court sufficiently educated on this issue that it's...
Do you feel compelled to respond?
I don't feel compelled to do anything in this court, Your Honor,
All right, thank you, Mr.
other
Kelberg.
than to hopefully be courteous.
All right, thank you, sir. All right, counsel, we've used up, we have one other issue, the issue as to the use of the autopsy photographs. And I did receive from the prosecution a complete set of autopsy photographs that are placed into 2 groups. photographs that they do not wish to use and those that they do wish to use. However, I must say that the letter that accompanied the photographs did not tell me for what purpose the prosecution wished to use particular photographs. And my guess at this point is that we will not see the autopsy testimony for quite some time, perhaps 3 to 4 weeks, if I'm lucky. Do we agree on that? And Dean Uelmen, I understand you have to go back to Stanford.
Well, I was going to argue the sanctions issue, so I may remain over until tomorrow morning to do that.
All right. Do you want to address the sanctions issue? Can you do it in 5 or 10 minutes?
Certainly.
All right.
Your Honor, if you recall, I had asked for time
Yes.
on that. That's why you set it for tomorrow morning, sanctions on the late
That's
disclosure
right.
of the videotape.
Okay, I did do that.
All right. I'll be able to remain until tomorrow morning.
All right, then as to...
With respect to the autopsy photos, we believe that the court needs to engage in the 352 balance with respect to each individual photo, and that perhaps this could best be done in chambers where both counsel have an opportunity to address the admissibility of each photo and the availability of alternative photos which may not create the same problems.
I might add as well, it would be tremendously helpful to me if I had a one-sentence explanation as to each photograph, why it's relevant or why you seek to introduce it or as to what issue. Because to merely give me a list and expect me to figure out, I mean, I can guess as to a lot of these things, but some of them, the intent may not be clear to me. So it would help me tremendously if I had a one-sentence explanation as to each one of these photographs.
That does not present a problem for us to do, Your Honor. Obviously, we're not going to do that today, and perhaps we can coordinate a schedule with Dean Uelmen that's convenient to him, to the court. I think the court's correct that you won't have to see me again, at least, for a fair amount of time, so perhaps we can just put it over. Our primary purpose in bringing the motion was to allow us to know which photographs we were going to be permitted to use so that we can prepare the appropriate exhibits, rather than at the last minute, as the court probably remembers from its days of trying cases, getting the photo mount out at the last second and sticking photos on a board.
Saw it this morning.
I have no doubt of that.
Yes.
But if that's good with the court, that's fine with us.
All right.
So does the court just want to take it off calendar and let us...
What I would like to, I would like an additional briefing from the prosecution as to each individual photograph they intend on using.
And does the court have a time frame when the court wants to have the hearing held on this?
How about if you submit that to me in 10 days' time?
That's fine.
All right, and then we'll schedule it in accordance with Dean Uelmen's schedule. But I have the feeling we'll be mired in this stuff for a while. All right, anything else, counsel?
No, Your Honor.
No, Your Honor.
All right, thank you.
Thank you, Your Honor.
All right, do I need to change court reporters? Can you go to 3? All right. All right, let's have the jurors, please. our jury panel. Good afternoon, ladies and gentlemen. All right, Mr. Goldberg, Mr. Fung is on the witness stand undergoing direct examination. Good afternoon again, Mr. Fung.
Good afternoon.
You're reminded you're still under oath, sir. Mr. Goldberg, you may continue.
Okay, Mr. Fung, I just wanted to go back for a minute to the discussion of the collection of blood stains and substrate controls. When you collect a stain, if you apply a swatch to that stain and it does not collect the entire stain, what would you do?
I would select another swatch, wet it, apply it to the stain, and put it in the same plastic bag as the first cloth swatch for that item.
And on some of the stains that were collected in this case, or in fact most of the stains, were there more than one swatch that was used to collect the stain itself? I'm not talking about the substrate control, but the stain.
Yes,
All right. And do all those go into the same plastic baggie together?
yes,
Right. And then that baggie, or that plastic bag containing the various stain swatches, and the other plastic bag containing the cloth control go where?
those two bags go into a coin envelope with the photo ID number corresponding to the stain.
Okay, now, when you say the photo ID number corresponding to the stain, for example, right before we broke, we were discussing the chart depicting the stains at Rockingham, and there were items that were labeled, for instance, 7 or 8. So are you saying that the coin envelope into which 7 went in would be labeled 7?
Yes,
Sustain.
Okay. Well, with respect to the stain that has a photograph, a little card in the photograph that says number 7, what would the coin envelope be numbered?
the coin envelope would also be labeled 7.
Okay, and with respect to a stain that has a little marker next to it that says 8, what would the coin envelope be?
The coin envelope would be 8.
Okay. Now, at approximately 9:30 or so in the morning on the 13th of June, if you need to refer back to your crime scene checklist, you may do so. Did you collect another piece of evidence at the Rockingham location?
Yes,
Was that one that you personally did?
yes,
Do you recall whether Andrea Mazzola went with you on this particular occasion to collect this piece of evidence?
I recall that she was not present when I collected it.
Okay. Did anyone go with you to show you where this was?
Yes,
Who was that?
Detective Furman.
All right. And what was it that you went to see at approximately this time?
At 9:30, or approximately at 9:30, the glove was collected at that time.
All right. Where was that?
The glove was on the south side of the residence at Rockingham.
Now, when you are collecting items of evidence that contain possible biological material, but other than blood drops, what technique or techniques will you use?
I will use one of two techniques. One is to wear a pair of gloves and pick up the item and place it into a paper bag, or I will use a scoop technique where I will place the bag next to the item to be collected and push it in with a card or pencil.
Your Honor, I have a pair of gloves that is marked as People's 163C for identification. May I approach the witness?
You may.
Showing you what we've marked as 163C. What is that?
Those are a pair of latex gloves.
Okay, and are those the type of gloves that you would use at a crime scene?
Yes.
All right. So you could have used either a glove technique or this card technique that you've described, where you don't touch the item at all.
Yes.
Do you recall specifically which one you used in this instant with regard to the glove that Detective Furman showed you?
I don't recall which one I used.
Okay. But it would have been one or the other according to your ordinary practice?
Yes.
There is no third way that you do it?
Not that I can recall, no.
Okay. So, with respect to this item, do you recall how you packaged it?
The glove was placed in a paper bag, and the bag was labeled.
Is that what is done with items of clothing like that? A glove, it's put in a paper bag generally?
Depending on the size, yes.
But you don't put it in plastic? A plastic bag as opposed to a paper one?
Generally, no.
All right. Now, when you saw this item prior to you collecting it, whichever technique you used, what did the item appear like?
The item appeared to have some brownish, reddish stains on them. It appeared to me to be somewhat dry with some shiny areas on it.
When you first saw it, before you had a chance to inspect it at all, carefully I mean, when you first glanced at it, how shiny did it appear?
There were just some areas that had a sheen to them.
What to them?
A sheen, a shininess.
Okay. And did you do something further to look at it to determine whether, in your opinion, it was dry or wet at that time?
No, I did not.
Okay. What makes you think that it was more likely to be, well, maybe I'm misstating your testimony. Did you testify that, in your opinion, it was more likely to be dry than wet?
Yes.
And why do you think that?
My experience with bloodied clothing and their appearance lent me to that estimation of whether it was wet or dry. It appeared to me to be dry.
Your Honor, at this time, I'd like to mark as People's 165 for identification, part of the contents of a box that has a number of items in it. I don't know how the court wants me to do that, whether the court wants me to mark the entire thing as 165. I won't be introducing all of them.
All right. How is the box labeled at this point?
Well, the box is labeled with an evidence tag that says booked, date booked 6/13/94, and it appears to contain the DR number, in this case 9408174131. It says name book 2, Simpson Nicole, and it has contents 9, 10, 18, 27, and 40 and 53 are crossed out.
All right, which item number in that box are you intending on offering?
9.
On this? 9?
At this time.
All right. Sure.
If we can mark the box for identification, and then he can just signify what he's taking out, and we can then use the item. If we could mark the box with a separate number for identification, and then the individual item can be separately marked.
165, the box and contents at this point.
Oh, I'm sorry, it's 164, Your Honor. I
164.
made a mistake on my notes. May I also place a 164 on it, just so there's...
Yes, you may. Thank you.
Sir, I'm showing you a box that's been marked as 164. Can you just take a look at the number that says DR number for us and tell us what that number refers to, or what significance that has in the Los Angeles Police Department?
There's a number in a box labeled DR number that is 940817431. That number is used to identify different cases within the Los Angeles Police Department.
So each case has its own DR number assigned to it?
Yes.
Is that the DR number of our case?
Yes, it is.
All right. And when you packaged up various evidence, would you have used that DR number?
Yes.
Could you now open the box for us and describe what you're doing for the record?
I am using a pocket knife to cut the tape along the top seam of the box. I'm opening up the box. Did you want me to remove anything?
If there's an item number 9 in there,
There's a bag within with the item number 9 and the DR number 940817431.
okay, now taking a look at that packaging, is there anything about the packaging that you recognize?
Yes. In black, I see the item number that I wrote on it and my initials.
Okay, the item number being 9.
Yes.
And is that what you assigned to the number, the glove that was found on the south side of the Rockingham location?
Yes, it is.
Okay, is there anything else in that package? I mean, in the box, right?
In the box, there is a coin envelope with item number 10.
Do you recognize anything on that?
Yes. There is the item number 10 and my initials.
Okay.
And underneath the tape, I can kind of make out the DR number. Also in the box is a bag with the number 18 on it, my initials, and again, the DR number. And the last item in the box is a bag with the number 27, the DR number, and Miss Mazzola's initials.
Your Honor, do we have any latex gloves at the courthouse? I don't want to use my exhibit over there.
I guess you weren't a Boy Scout.
Excuse me?
Never mind.
Well, I tried to be, but
Mrs. Robertson has latex gloves.
sir, could you open up the envelope that's number 9 for identification and tell us what you're doing?
I am unfolding the bag. Breaking the seal. Reaching in the bag. And within the bag is an envelope. continue?
Yes.
Scissors or a knife?
Scissors. Thank you. I'm cutting along the bottom edge of the bag. And within the bag is a glove.
Now, with respect to the package that you just took that out of, can you hold that up so that we can see it with the evidence tags on it? Okay. Now, does that appear to be a package that was a transmittal package that someone else put it in, or is that something that you put it in?
Sustained, rephrase the question.
Okay. Is that your package or someone else's?
This is somebody else's package.
Okay. So the package that you used is the brown paper bag that has item number 9 and your initials on it?
Yes.
Okay. And does that appear to be the item that you retrieved from the Rockingham location? I'm not talking about the
Yes.
package, I'm talking about the glove.
Yes, it is.
All right. Can you hold that up for us so we can see? Is there a size label in there, Mr. Fung?
There's not one apparent.
Okay, that's all right. You don't have to look any further. Can you repackage that for us now, describing what you're doing for the record?
I am placing the glove back in the white freezer storage envelope and placing the envelope and the glove into the brown paper bag. And placing the bag back into the box.
I'll have the clerk reseal it. Mrs. Robertson, at the conclusion of the day, reseal the envelope, please. Excuse me, the paper bag. Mr. Goldberg.
Thank you. Now, in addition to the glove at approximately 9:30 or so, was there any other item of evidence that was collected by either yourself or anyone else in your presence?
Yes,
What was that?
that was a blue plastic bag or container of some sort.
And what item number did you assign that?
That was item number 10.
Did you see the packaging for that being the item that you took out and described as number 10 a little earlier?
Yes.
Okay. For the record, he's holding up what appears to be a coin envelope with red tape and blue tape on it.
Red, yellow, and blue.
Kind of festive looking. And how did you first get possession of that item? 10,
Item
back
number
at
10.
Rockingham? Yeah.
That item was on the other side of the fence, and Detective Furman collected it and handed it to me over the fence.
And what was it,
The
item that he collected?
It was a blue plastic container of some sort of baggie or something. I haven't been able to identify what exactly it was.
Okay, but was it a hard type package or a soft bag-like package? I mean, when I say hard, I mean like Tupperware, or is it more like a baggy type material?
No, it's more of a soft plastic.
Okay. Now, was that the last item of evidence that you collected or was collected in your presence at Rockingham that morning?
Yes.
Okay. just have one moment, Your Honor.
Certainly.
Sir, you said that you didn't know exactly what the baggie was, item number 10. Did it look similar to anything that you've ever seen before?
No, but it might have been a gauze wrapper, but I'm not sure.
Okay, could have it been sanitary napkin type wrapper?
Sustained, leading.
Could have it been anything other than a gauze type
Could
wrapper?
have been.
All right. Now, approximately what time did you leave the Rockingham location?
We left the Rockingham location at approximately 10 o'clock that morning.
All right. And when you left this location, would you have kept on any latex gloves that you were wearing during the evidence processing and collection?
No.
What would have happened to those?
Sustained, rephrase the question.
Sir, do you have a custom and practice with respect to what you do to latex gloves that you're wearing at a crime scene after you leave the scene?
Yes.
What do you do with them?
I will remove the gloves and place them in a designated trash bag.